SJC-12273, Commonwealth versus Ortiz.
I think just a cipher.
Good morning. May it please the court, Assistant, oh, I'm sorry.
One second, Ms. Payne. We appreciate your enthusiasm, but hold on to it for one brief moment.
SJC-12273, Commonwealth versus Ortiz.
May it please the court,
Now you may release your enthusiasm.
Assistant District Attorney Cynthia Payne for the Commonwealth. With me is Assistant District Attorney Bethany Lynch. The Commonwealth is asking this court to reverse the motion judge's decision and find that the officers did not exceed the scope of the defendant's consent. Here, the scope of consent standard is reasonable, whether in the light of all the circumstances, a man of reasonable caution would be warranted in the belief that some limitation was intended by the consent given. Here we have a proper stop. The police officer asks if there are any drugs or guns in the car, and the defendant says, "No, you can check." The defendant.
What do we make of the language issue?
I would suggest, well, the motion judge found that there was no issue in the initial circumstances.
He did say it was a factor
Not,
in his legal conclusions.
he found that the initial consent was voluntary and reasonable, and there is a,
He was certainly bothered by the language.
correct, he was bothered by the language. However, at the time, the defendant, according to the motion judge, properly, the defendant gave consent. And I would suggest that once the defendant consented to the search of the car, in the car, the police officers could search anywhere in the car.
And in the, I gather the question was, is there anything in the vehicle we should know about? And the answer was no, you can check.
That's correct.
And the word "in the vehicle," you mean to include the hood?
Yes, under the hood, anywhere that's in the vehicle.
So how far, so you say, yes, you can search my car, and then they can go in and they can essentially undo the engine and open up the gas tank and
Well-
spend some time going through various radiators and everything else in the front of the car? That's within the scope of the yes, you can check inside my car, or you can check in the car?
I would suggest it must be reasonable. Here, the police officers did not use any tools. There have been a number of cases outside the jurisdiction in which the courts, various courts have found that where tools are used, that is not reasonable.
Okay, but he removed the air filter.
Correct. He lifted up the air filter and saw the bag with two guns inside. Here, the defendant, who was clearly right in the area, did not limit the search. The defendant did.
The out-of-jurisdiction case involves taking the vehicle to a garage and they transport the vehicle, correct?
Correct.
And then they use tools to rip it apart, basically.
Correct. You're talking about the Troxel case, correct? In that case, I would say it's certainly distinguished from our case. There, the defendant was only stopped for speeding. The stop was longer than the case at hand, and the court obviously parsed the language really narrowly. The dissent in Troxel, of course, said "in" means exactly that, "in." A engine is certainly necessary to motor the car, and "in," as long as "in" is okay.
So if the police come and they get consent to search someone's house, can the police show up with power tools to start ripping the wallboards apart?
Well, I would suggest that there are, no, if it's not reasonable, or if the defendant has continued to show his consent. If
So once the Sawzall comes out, the defendant has to say, whoa, 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 stop?
Well, I would say here, there was no limit.
How do we decide what's reasonable in the circumstances?
In these circumstances, there was no destruction of the car. There was a lifting up of the air filter, and inside were the bag of 2 guns.
Searches always have to be related to the scope of the search always needs to be related to the need to search.
That's correct.
So what's the need to search in this instance?
The police officer asked, do you have anything I should know about? Actually, he also asked any drugs or guns in the car. He alerted the defendant as to what he'd be looking for, and I would say that narrows the scope.
Can we go back to Justice Gaziano's first question about language, please? So, the defendant who speaks limited English says yes. Then he's in handcuffs. Put aside whether he's in custody or not for the moment, but he's in handcuffs, and there's a language issue, and then the police go under the hood. When you take into account reasonableness, and now we're inside the hood, underneath an air filter, somebody's in handcuffs, and there's a language issue, is that beyond the consent?
Well, the fact that there's a language issue is not necessarily relevant to the fact that under the hood is being searched. The police officer asked, the defendant clearly, who was right there, could see the
That's
hood
my
being
point.
removed.
That's my point. He may have spoken English well enough to have said consent, and then all of a sudden he's in handcuffs, and now they're from the body of the car underneath the hood, and the question is whether there's a language issue there in conjunction with the handcuffs, where he's not really able to say consent, and that it's more of a acquiescence to police conduct in that situation, that he's sort of figuratively lost his tongue to be able to say, this is beyond where I want to go.
I realize you said put custody aside, but it's up to the defendant in these cases to object. Here, the defendant.
But don't, in our case law, we do not require that they advise them of their right to stop the search when they consent.
That's correct.
So did he know that he could do that?
Well, I would suggest that he never looked askance at anyone. He never made any move, according to the testimony.
Was he really in any position to make a move? He was in handcuffs.
When I say make a move, he never showed any
Well, I
distress
mean-
or any.
But he was in handcuffs, so he wasn't really in the position to object at that point, was he? I mean, I understand the point that you're making about him having given consent, but once you're in handcuffs, it's sort of tough to feel like you've got any power to do much of anything.
But we're still under that initial scope. It's not like it had been extended to, there's a clamshell on top of the car, can I search in there? We're still in the car, and
And it would have been okay to look in the glove compartment, correct?
that's correct.
And the trunk?
That's correct.
How long does this, sorry.
No, go
How
ahead.
long does this, I mean, they have a dog search, right?
Yes.
So is he kept there, so he consents, how long, do we have any sense of how long this happens? The judge doesn't make findings on that, right? Do the officers testify to that effect?
From the time of the stop to the time that the car is released to the third party was 20 to 25 minutes, so less than that.
So they stop the car for a noise violation, essentially. They get consent, they bring in a dog, then 25 minutes later, they lift the cap up and find this. Yeah, I'm just trying to understand, I guess, the consent will go indefinitely?
No, and I would suggest respectfully that it was less than 25 minutes. Because from the time of the stop, and there was some initial, as to why he was stopped, et cetera. But no, I would suggest it has to be reasonable.
So when we look at what a reasonable police officer would believe, are we looking at time? How long it's gonna take to search, whether tools are used? What other factors are we looking at?
Well, in light of all the circumstances, a man of reasonable caution would be warranted to believe that some limit was intended by the consent. I would suggest that the court looks at whether tools were used, how long. This would have been within the realm of reasonable. This was not a search that lasted for hours. This was not a search in which the police officer brought the car someplace else. This was a relatively short search. And again, the Commonwealth would argue that because the engine is in the car, because under the hood was included in the car, that it was objectionably reasonable. And in fact, the case of Commonwealth versus Cantalupo, a search of the defendant's shoe where the defendant had opened up his suit jacket and said, "Search me." The court found that it wasn't just a above-the-belt sort of search, and the court found reasonable that the police officer was justified to search in the defendant's shoe. Again, the defendant, there as in here, did not object, did not limit the search at all.
Let me be clear. I mean, I understand, I think your argument that the trunk was the hood was within the scope of the consent. But if it was not within the scope of the consent, is it your view that his silence when they opened the hood was a new grant of extended consent?
I'm sorry, could you?
As far as I can tell, the judge's findings say, no, his consent was only to the cabin of the car. Then the judge goes on to say that the fact that he was silent when the search was expanded to include the hood was mere acquiescence and not consent. And so I understand that the judge essentially is saying the initial consent was only to the inside of the car, and then the judge considered, did he expand his consent to include the hood by remaining silent when they began to search that? And the judge said, no, I don't view his silence to constitute consent to a search of the hood. Is that your understanding of what the judge found? Or,
Yes.
and is it your view that if we were to disagree with you and say that the initial consent was only to the inside of the car, that we should view the defendant's silence when they expanded the search to constitute a new consent to search of the hood?
Well, the Commonwealth is not conceding that in does not mean the engine compartment, but
I understand that, but I guess my question to you is if we were, I don't know whether we will, if we were to say, no, the initial consent was only to inside the car, is it your argument that as a matter of law, we should say that his silence when they opened the hood constituted consent to search the hood?
yes. The fact that the defendant did not object, the fact that the defendant did not object indicated that there was no limit on the search.
Let me just try and understand how much deference we have to the factual findings here and trying to figure out what's a factual determination and what is a ruling of law on this motion to suppress. So isn't it really sort of a case-by-case basis of the extent of the consent? And you take the situation and say, well, based on what this defendant said in this circumstance, what was the extent of the consent? And you have this defendant with limited English and in handcuffs, and the judge is determining that the initial consent was not including the hood. Number one, Is that, do we have deference to that because it's a factual situation and look at this situation? Or do we say as a matter of law, no, a consent means the whole car? And secondly, going to Chief Justice Gantz's point, the judge made an analysis and made a determination relative to what happened from the hood, from the inside to under the hood. Is that a factual issue that requires deference, or is this an issue of law that we're applying doctrine to?
I would suggest that this is an issue of law, that this court is entitled to, this court can independently review the ultimate findings and the conclusions of law made by the motion judge.
Why is that? I mean, the judge made findings based on the specific facts of this case as to what was reasonable for this police officer to believe based on what the defendant had said. Why is that not a factual finding?
Well, the judge also found that there was consent, that there was valid consent, and once the judge found that, I would suggest everything, what he found later was a ultimate finding and a conclusion of law.
All right, thank you.
Thank you.
Mr. Levin, still good morning.
Good morning. May it please the court, Patrick Levin on behalf of Anthony Ortiz. I'll just pick up right where we left off here. This is something that I was thinking about in preparing for the argument today, and I did notice, I don't actually have the cases at my fingertips, but I noticed that in the courts of appeals, in the federal courts of appeals, different circuits seem to apply different standards of review to questions about the scope of a consent to search. And some circuits appeared to do a pure de novo review as though this was a pure question of law, and other courts apply a clear error standard to questions of scope while reviewing the question of voluntariness de novo. I think the better view is the latter, that the question of the reasonable scope of a consent is more of a factual question that could be that the motion judge, Justice McDonough in this case, would be entitled to deference on that question.
Can you distinguish Florida versus Jimeno?
Can I distinguish it?
Yeah, isn't in that case they said in the car is just in the car? Wait, so they said it's in the car.
So in Jimeno, you see the package or the bag. It's a brown paper bag at issue in that case is on the floor of the car, and the question was whether it was reasonable for police to look inside the bag in the course of their search. And the defendant had the police explained to the defendant that he didn't have to give consent to search his car, but he said, no, go ahead and search the car for drugs. And so what the Supreme Court says is that the consent to search the car for drugs imports consent to look inside the paper bag that they found on the floor of the cabin of the car, because it's reasonable. The test of objective reasonableness, what would the typical reasonable person have understood by the exchange between the officer and the subject? That the typical reasonable person, when they look at that exchange, would not think by search my car, someone means you can just look inside the car, but you can't open up the brown paper bag on the floor.
So in this case, what should the police officer have said? Because he wasn't asking for consent. He was just saying, is there anything in the car I should know about? And the defendant said no and went further and said, you can check, and gave affirmative consent to check the car. Why wouldn't the police have an opportunity to look at the whole car?
Well, the question again is an objective test about what a reasonable person would understand from.
Could they look in the trunk?
I think that's a close question on these facts. I submit that the answer is no, that
Well, it has to be no for you.
no, I think the trunk is very different from under the hood in the engine compartment, because the trunk is an area of the car.
The judge found passenger compartment, right?
Yes, that's right. What the judge's
Not the trunk.
That's right. And the judge's interpretation of the scope of the consent did not include the trunk. And I think that's correct, but I think it's a much closer question than whether they could go under the hood and start taking the engine apart. Because the trunk is an area of the car where you might expect someone to carry something. And we're not talking about a reasonable police officer and what a reasonable police officer might do in the course of searching a car. We're talking about an objective, reasonable person and what they would understand to have been the scope of the consent that was granted. And so when the Commonwealth says, well, in the car means in the car, and therefore that includes the engine, that's begging the question. The question is, what does an ordinary person mean when they say something is in my car?
But then I'm getting confused about Justice Lowy's earlier question then, was if Judge McDonough found that the consent was only to the inside of the car, and Jimeno says that we look at what a reasonably objective person, so can we decide that that was not a reasonably objective interpretation of that, or do we owe him deference as a fact finding that when he interpreted consent, you can check it only meant inside the car? I'm now confused of what's a fact and what's a legal conclusion.
So I think the standard this court typically applies to suppression motions is that you will defer to subsidiary fact questions and independently apply the constitutional principles. And I think
I get that generally. I'm just trying to understand here what we're dealing with.
so. The question of the subsidiary fact questions certainly, I think, are more or less uncontested in this case, and so I think it's.
But the key issue is, to me at least right now, is Judge McDonough found consent is limited to the car based on you can check. Is that a factual finding, or do we say that we look at that as a reasonable police officer would not make that conclusion?
Well, I think it's important that the standard actually is not reasonable police officer. It's reasonable person observing the interaction between the suspect and the police officer. And so the question of what a reasonable, of what a police officer might know about where things are hidden in a car.
Forget about, I misled you on that. So accept just what you said, the reasonable person observing the interaction. And if the judge found that consent was limited to the inside of the car, can we decide that a reasonable person hearing that comment would not reach that conclusion? Or do we have to defer
Yes,
to
I
the
think
court?
that's this court's role.
Okay.
I want to talk about the language barrier. It's important to remember in these cases that this is warrantless searches are presumptively unreasonable and unconstitutional, and it's the Commonwealth's burden to show that a search without a warrant was reasonable. And so the question of what the defendant could understand cannot inure to the Commonwealth's benefit.
Are you talking about the very beginning when the first interaction, the first time he spoke in English to the officer? Because wasn't that a consent? Do you admit that that was consent to search?
Yes, I'm not contesting the consent itself.
Okay.
I agree point by point with everything that Judge McDonough said in his order.
Okay.
But the language barrier, the question of what the defendant intended would be approached with caution by a reasonable person, where the defendant doesn't speak the language that he's being spoken to by an officer of the state.
Really, really the issue in this case? Because even if somebody spoke perfect English, wouldn't we still be confronted with the same question, which is whether lifting the air filter under the hood is reasonable and is within the scope of the consented to search?
Yes. And I think even if the defendant spoke perfect English, that Judge McDonough's order would still be correct. But the fact that he doesn't speak much English cuts against the Commonwealth, and the reasonableness of the police conduct in this case has to be viewed in that context. And if there's a question, if a reasonable person observing the situation would still have a question in their mind about what the defendant intended during that interaction, then the reasonable thing for the police officer to do would be to clarify and to ask a follow-up question.
Is that similar to the invocation cases?
It is. Commonwealth versus Garcia in particular.
That's what there's, maybe I should get a lawyer.
Right.
Those types of cases, right?
Right, where this court repeatedly has
But
instructed.
But here, it was, do you have any guns or drugs in the car? Go ahead and check.
Right.
You don't have the ambiguity that you would have in the invocation type cases that you refer to.
Well, I mean, clearly there is some ambiguity because we're here trying to figure out exactly what is meant by you can check in the car. And I think it would have behooved the officer to clarify, particularly with a suspect who he knows can't really speak the language that he's being spoken to in. And the question of, if I were to ask someone, do you have such and such thing in your car, and they say no, you could go check in the car, I think they would be very surprised if I went outside and popped the hood and started fiddling around with the engine.
Doesn't that go ahead. Doesn't that depend? I mean, if my mother asks, is it in the car? And she says, I take go check. Yeah, I think she's going to go check in the compartment. But if the police officer says you can go check, don't you think the police officer is going to look wherever they can find the stuff? Particularly they have experience knowing people hide lots of stuff in the engine area.
Well, that may be, but this objective test, it doesn't account for what the police know about how to investigate crimes. It's a test about a typical reasonable person, and a reasonable observer of this interaction, I submit, would not expect a check in the car to result in examination of the engine compartment and disassembly of the engine.
Mr. Levin, aren't you saying this, that as a matter of law, consent does not include in the hood under the air filter? But even if it did, in the circumstances of this case, when you take a reasonable person and you put into account that he's in handcuffs at the time, and there's a language issue, that when the police officer went from the body of the car to under the hood, that Judge McDonough is then saying, in the circumstances of this case, as a factual matter, I believe that is just a mere acquiescence to lawful authority. Yes,
I think that's right, Justice Lowy. But what I would say is that the fact that the defendant was in handcuffs on the side of the road after just having confessed to an arrestable offense, the question, the technical question of whether he was in custody is totally irrelevant. This is a guy who has been shuffled off to the side of the road in handcuffs. His person has been searched, and now the police are searching his car. The idea that he's going to pipe up and say, no, stop now, is totally unrealistic.
Whether it is or not, is it a factual determination by Judge McDonough that it wasn't consent at that point? I think it really matters if you're wrong about under the hood, I'm not saying you are at all, but if you're wrong under the hood, as a matter of scope, but Judge McDonough says, in the circumstances of this case, that looking at what a reasonable person would think, that they should be able to say, hold on, stop now, that's not what I meant, and that he couldn't do that. I'm just trying to understand whether that might now also be a fact question, if that Judge McDonough's findings are entitled to deference.
Well, I do think that Judge McDonough's findings are entitled to deference, and I certainly do think when you look at his order, he does appear to be making a factual determination about that question at that point in the encounter. So I guess the answer is yes.
But is that consistent with what you just told us about, we look at what a reasonable person observing the interaction would conclude, not what the judge specifically found? Isn't this even more like a reasonable person standard? Because we're interpreting nothing but inaction. So a reasonable person observing the defendant in handcuffs after he gave consent, what would a reasonable person conclude about whether that's acquiescence or, further consent? Isn't that what we're doing?
Well, the question of the initial consent is slightly separate from the question of whether, as a matter of fact, the consent remained effective when he was standing in handcuffs at the side of the road.
But it looks like it seems like it's the similar type of analysis, because it's not just a purely factual analysis, right? The acquiescence issue is also a legal issue we have to look at. But it's a question, not an answer. I don't know.
I see that my time is up, so unless there are further questions.
Great, thank you.
Thank you very much.